Adviser Hynes Legal. With me today, literally with me today, Frank Higginson, partner of Hynes Legal. Frank, welcome.
Hello everyone. Obviously one of our training days and we've grabbed the boardroom. We're not sure if the lighting's quite right, but hopefully the sound quality is fine.
We've got mood lighting, to say, in here. But so long as you can see most of us, I think that's the important thing. Today we're actually introducing a new visual element into the webinar in new ways. So,
attempting to, or actually?
We are attempting to. The attempting to refers to the various, how shall we put it, technical challenges we've had this week. Fingers crossed it all comes off today. Anyone who's watching this and you can't see or hear us, obviously shout out please. We'll do what we can to try and fix. But if I hear from you, we'll assume it's perfect. As always, don't forget to like and share. Make sure you register for these. That's how you can find out what's coming up. Gosh, it's almost the end of it. Past halfway June already. Starting about July options.
End of financial year looms.
It does. You can pop questions up today live, and you can also post some afterwards. We'll try and get to as many of those as possible. Today, though, bylaw enforcement, Frank, and look, it's fair to say that this is a drawn-out, cumbersome process at times, isn't it?
It is, and I think probably one of the things that we need to emphasise today is we're talking about what the law actually allows people to do. It's not going to be as quick as what people would like. It's not going to be as immediate. It can be cumbersome, but there is a process. And like it or not, this is the process that the legislation actually thrusts upon us all, and there's just no way around it. So, and stage 2 of the Strata Working Group reform will be dealing with a lot of bylaw things. So, at that stage, if you want to have a, I was going to say, whinge suggestion about how it might be improved, that's the time to talk to government. But for the time being, what we're talking about today is the way the process works, whether you like it or not. So, I'm not trying to be too brutal about that, but I just know both of us have had plenty of conversations with clients over the years about there has to be a better way. And yes, there might be, but there's no other lawful way to do it other than the way we're talking about today.
I think that's right, Frank. And I think one of the things I always hear when it comes to bylaws is, we're just going to breach them. We're just going to issue a breach. We're just going to... That's just merely one part of the puzzle, and you're going to find out that very, very shortly. A very quick reminder of why it's important to get this right, and who cares anyway if the bylaw enforcement is right or not. Remember that bylaws are the primary tool by which the body corporate regulates. Regulating the important word here, what goes on in the body corporate. It's also the way in which, I suppose, all people, whether they're tenants or whether they're owners, are involved in the integral part of the body corporate. So remember, bylaws apply equally, regardless of whether you're a lot owner or whether you're a tenant. Occupier is correct.
That's the really interesting thing. And again, tenant is not a word that's used in the legislation. Occupier is. So you're an owner, we're an occupier. You can't mix it up. The bylaws apply to both owners and occupiers.
Without distinction, it should be said as well. The really important point to make about bylaw enforcement is this one, is if the process, you might think it's incredibly convoluted and time-consuming, but if it's not followed, you go right back to the start. So you can spend weeks and months, in some cases years, I suspect, Frank, going through what you think is a bylaw enforcement process. But if you've missed one step of that process, the whole thing collapses at that point, and you basically have to restart. So it's essential that you get it right. And one of the analogies I think we always talk about, Frank, bylaw enforcement is effectively when one person is making an allegation against another. So, Frank, I think you have done this wrong. So when that happens, natural justice kicks in. Frank, natural justice 101 in 30 seconds.
It's about the vibe you're on at the castle. It's not a matter of unfairly pinning people. So if you're accused of something, you've got to have a chance to respond to it, to answer to it, to contest it. So the whole, and this is where bylaw enforcement tends to get a little bit more difficult. It's not like a civil dispute in the sense that, but Chris and I have an argument over money. What it's going to be is really affecting someone's ability to really, because the bylaws relate to the use of common property or people living, it's affecting someone's home life or the place they live. So in that sense, it's a fairly serious process to go through. So it's not something to be undertaken lightly. It is absolutely something that, like all legal systems, and adjudication is one of those, that you need to dot the I's and cross the T's, and you need to make sure that people who have allegations made against them understand what they are and have the chance to respond in a timely and meaningful way. And then, from a committee perspective, that the sound is very echoey.
Sound is a bit echoey. That's because this room is a bit echoey. So, hear what you're saying there, Neil. This might be about as best as we get it on the echo front. So long as you can actually hear us, that's probably the best we can hope for. Look, and I think also we haven't got the most awesome Wi-Fi here today, everyone. So please bear with us. We'll do what we can on this one. Let's get into it then. Today we're actually going to be looking at the Commissioner's Office flowchart for enforcing bylaws. And this was something that I didn't initiate when I was Commissioner, but I worked with the entire staff to actually draw this up. And it was because we kept having the same issue over and over. People would come to enforce a bylaw and get it wrong. And some bright spark, it wasn't me, I emphasise, some bright spark said, oh, wouldn't it be good if there was like a diagram to show the step-by-step process? And everyone went, yes, that's a fantastic idea, let's do that. I can tell everybody watching, it took a long time and there were a lot of robust discussions about what should and should not be in the flowchart. It went through our information team, it went through our case managers, it went through our conciliators, and it went through our adjudicators, importantly. So this is not simply a bunch of figures thrown onto a page and hoping for the best. I can assure you this went through a lot of best plans. So we're going to try now, fingers crossed, to introduce to you what we're talking about. So this is the Commissioner's Office Practice Direction 6, Bylaw Enforcement. Now, there's a lot of information there and it's all essential information. But what we really want to get to is this bit down here, the bit where Frank and I have drawn on it.
Chris has drawn on it, that's not my scribble.
So yeah, we're defacing government property here. So it's that, and we'll provide the link to this practice direction towards the end of today. You scroll down a bit after the information and here is your flowchart. Frank and I think the flowchart is effectively comprised of 5 parts and we have put different colours around each part. So let's move into it then, Frank.
And I think probably the one caveat that I'll throw out there for everyone is this presupposes that the bylaw you're seeking to enforce is valid. So we're not having the conversation today about what is a valid bylaw. Obviously, there's been, I wouldn't say 1,000 words, but there's been quite a few words about what makes a valid bylaw, what doesn't, drilled into specifics. So this is working on the basis of the bylaw you've got to valid. That is absolutely the first port of call, is to make sure that what you're trying to do is something you can do. But assuming that's the case, then we're into the actual process here at the moment.
So the first colour that you can see behind us, I hope everybody can see behind us, refers to the first step. Before we get there, a link from us, Frank was talking there about valid bylaws. We're just popping a link up there in the chat for our bylaw review service through Hynes Legal. And that's for circumstances where you might have a suspicion that there might not be a valid bylaw or that your bylaws need a bit of work. That link should now be up on the screen. So your first one, that light green colouring, is the phase, Frank, that we're calling allegation.
It is. You've done something wrong. You've breached the bylaws. You're not doing what you should be doing. All those sort of things are what this first stage is. So, of course, I mean, any allegation starts with that sort of stuff. We're talking about you've breached bylaw 13, you're keeping a pet without approval, you're partying till 2 in the morning and actually breached whatever bylaw it might be in terms of nuisance or so on and so forth. So that is the allegation itself.
So it's one thing to, and I think it's really important to say, it's one thing to complain to the committee or to your neighbour or to the body corporate manager about noise, for argument's sake. It's another thing to actually back that up. So I say, you know, Frank, you're causing a lot of noise in your apartment. Frank, you're causing a lot of noise in your apartment. Yesterday at 2 p.m, I heard this thumping noise on the floor. It went for 4 hours. I recorded it. Then it started again at 7 o'clock. And then the next day it restarted. If you can't have that level of detail, I think it's pretty pointless pursuing anything.
Well, who do you actually talk about? It might not be me. It could be someone else. It could just be Chris making things up because he doesn't like me. You know, it's that evidentiary element that lots of these things fall over on. So if you're going to make an accusation, you've got to back it up with that evidence that's relevant and actually proves it. So the perfect world would be, in that example, some sort of logbook, and ideally some sort of recording. Here is Frank partying at 1:30 in the morning.
And then that leads to the next significant point out of allegations, Frank. You actually need to know who it is that you're complaining about. Sounds obvious, but there are so many instances where you know, let's take noise again for an example. You know there's noise happening, but do you actually know where it's coming from? Because if you don't know where it's coming from, how can you make an allegation against someone? You need to be able to source it. Pet disputes are a classic one for this, where there's a concern about a dog barking, for example. It's all well and good to say, this dog barking is disturbing me, but how do I know, or how does anybody know where that barking is coming from?
And one of the biggest ones we get in high-rise buildings is the poor owners that are on the ground floor that have litter come down and land on their courtyard area or otherwise. They get up in the morning, there's whatever it is there. It could be any one of potentially 30 or 40 stories times 2 or 3 units that actually threw the stuff off the balcony. It could be more than one. So it's really difficult from a body corporate perspective. It's all well and good to complain to the community about it, but even from a committee perspective, there's nothing they can do unless they know who was actually breaching the bylaw.
And where it's come from. Yeah. We've just put a link up there to an adjudicator's order that you might like to have a look at in relation to that topic. It backs up what Frank and I were just talking about.
And we'll also put up a link to section 1, which is really
section 180. Sorry, my mistake.
The key things that bylaws can and can't deal with, which really is where you'd say 90% of the invalid bylaws come unstuck.
Absolutely. Let's move on to our amazing drawing. We have moved on to section 2, which is the dark green colouring there, and this is what we're calling consideration. So you've made the allegation in step 1. Now there's a bit of consideration about effectively its validity, I reckon. Does the body corp actually believe what you're saying in that case?
Is there enough evidence to actually do something about it? And I suppose because most of these complaints will come from owners or occupiers to the committee about other owners or occupiers. Is it reasonable for the body corporate to do what has been requested of it by the actual owner? Remembering that bylaws, committees have a statutory obligation to enforce bylaws, but that means enforcement in itself, to me, means you're actually considering all of the circumstances that relate to that particular request. So it's not something to be done lightly. Again, back to that natural justice and back to that in terms of attacking, there's me being a lawyer again, attacking people's conduct in their own homes. It's a relatively serious decision that's sometimes undertaken a little bit too lightly. So it's not something for a committee to go off half-cocked. So it is, have we got all the information we need? Is there more information we'd like? Is it worth having a conversation with the lot owner concerned about it first before we go into formal breach notice proceedings and those sorts of things? That's that non-legal stuff we're talking about. Because as we know, anytime you threaten someone with something is not necessarily the best way to resolve it in the long term. The conversation is the easiest way to deal with it.
And that, absolutely. At this stage, what Frank and I think is really happening is that it's giving everybody a moment to pause. Do we actually need to pursue this? Can we actually pursue this? Is there another way? We've spoken just recently, I think, Frank, or a seminar, it was like, do you actually need to do something about it? Yes, bylaw may be being technically breached. Do you actually need to do something about it? Those are two separate questions, in our opinion. We are now moving on to part 3. Part 3 is the big red section there, and don't you love my fantastic arrow drawing there? Section 3 is decision. So, again, following that through logically, allegation, consideration, decision. And the decision here, Frank, is a decision of the committee, isn't it?
It absolutely is. It's not a decision of any individual. And I suppose if you were going to raise a red flag, one of the things that does cause, I think probably adjudicators to certainly slow down a second, it certainly does me, is when the complainant in relation to the bylaw breach is a member of the committee. You know what I mean? It's sort of, as much as we can talk about conflicts of interest, and certainly the people that are making the complaint shouldn't be part of participating in the decision about enforcing it. But one of the red flags is when it's the committee being particularly militant about enforcing something that affects one of them. You've got to be very careful to make sure that the process is followed and that everyone's given the chance to think twice. That pause is really important.
Oh, it's very important in that case. And remembering also that simply because I or Frank as occupiers or owners make a request of the committee to enforce a bylaw, it does not automatically follow that it will be enforced at this point. No. The committee needs to be satisfied that the allegation is made out. And again, going back to the dog example, Frank, you've alleged that my dog is breaching the bylaw through its barking. Comes to the committee thinks about that, they look at the material and they go, oh, okay, I can see the log and I've got the recording, we've got, and importantly, the big one here is corroboration, isn't it?
Yes.
So one thing for Frank to complain about the dog barking, if 10 other people all neatly around that lot are also making the same complaint, I think that's reasonable grounds for the committee. But if Frank's the only person complaining about the dog and no other neighbours of the lot are complaining about the dog, there's something amiss there, isn't there?
Yeah, well, does that point towards someone being too sensitive? But does it also point, I suppose, to someone working from home and everyone else not working from home? So that's the sort of factual things that need to go into the consideration of these complaints before you start executing people in relation to bylaw enforcement.
Which leads us very nicely to item 4, and so this is the blue line here, and this is the phase that we're referring to as challenge. So you've gone through the preceding steps, a decision has been made, and in this case, the challenge, if you like, is to the decision not to do something about it or to refuse to do something about it. So again, from the individual's perspective, Frank's lodged that complaint, for want of a better expression. The committee has said, actually, no, we are not doing anything about it, or even worse, they don't respond at all. And that shouldn't happen now under new legislation.
In the exact same thing in owner's motion. So from an owner's perspective, framed the right way, the committee's got to have an obligation to make a decision on something like this if the request is framed the right way within 6 weeks of the committee receiving it.
Let's have a look at this, because what happens here on the flowchart is that this branches off into 2 directions. And what these 2 directions are options to enforce the bylaw either through, I suppose you'd call this the orthodox and the non-orthodox way of doing it, if I could put it in those terms. The orthodox way is it goes through the committee. So the committee is the primary body for enforcement of bylaws. The legislation and this flowchart provides you for a second way, which is the individual can do it themselves. And so that's the blue circle that you can see there in the background. So on the left-hand side, you have got, I just need to go a bit further, everybody. So on the left-hand side, you have got the individual enforcing the bylaw. So the committee has refused. So I, as Frank's neighbour, am entitled to follow this complaint through now if I feel that that decision was wrong or not a reasonable one.
Yeah, or should be done, or for whatever reason you're unhappy with the outcome. You've got the ability to go and take action to enforce the bylaw. You're saying the committee shouldn't be doing.
Yep. And the way in which that happens, if you need to take this to the Commissioner's office, this is really important. This bit, it's all well and good for the individual to do that, but the individual must attempt to resolve the matter themselves. So go back a few steps. You have asked the committee to enforce that bylaw. The committee has declined to do it. So you are then exercising the option to do it yourself. well and good, but you need to try and resolve the dispute with the individual. So in this case, I've asked the committee to enforce a bylaw against Frank's barking dog. The committee has said no. I'm not satisfied with that because I was awake last night until 3 a.m. with the barking dog. So I'm going to follow it through. I need to try and resolve it directly with Frank.
Yep.
How do I do that? There's all the obvious ways. I actually go and speak with you about it. I write to you. We would probably urge against confrontations in the car park, I think.
Ideally, you get 7 in the morning, absolutely.
Yeah. We probably also urge against loud knocking on the door at 3 a.m. saying, shut up, you bloody dog. Probably, I'm picking no. I'm picking no on that one. Look, and that leads us to the final option, and that's the yellow section there. And that yellow section effectively is where you've gone through, body corporate has gone through all the steps, you end up in the Commissioner's office at that point.
So that's the allegation's been made. There's probably been some conversation around it. The behaviour continues, or the breach of the bylaws continue, and then you're off to the Commissioner's office to actually set an order that the behaviour you're complaining of cease. It might be by virtue of the removal of the dog. It might be that having no more parties. It's whatever the outcome is that you're seeking to prevent further breaches of the bylaws.
And you do need to know that if you get up to that step in the process, you will, unless there's a major exception, you will be required to participate in conciliation. And what that means effectively, Frank, is if you think you can get away with not talking to the other party through the process, that won't be the case. You will have to try and do that at some point. We'll put the flowchart up again at the end and just go through it as a whole. But look, what does all that tell us? First thing it tells us, it's convoluted. It's involved. There are a lot of moving parts to it. And what history and human behaviour tells us, the more moving parts are included, the bigger the chance something goes wrong.
Absolutely. And even the Commissioner's Office has produced Form 10s and Form 11s of the other forms that they've produced to actually bylaw breach notices, for want of a better phrase. They're not actually statutory forms. So you can do it your own way if you feel like it. But you've got to make sure that if you are going to do it, you tick all of the boxes which the legislation actually requires. So you can't sort of, you can't circumvent those things. And that's what Chris was saying earlier, is if you take, or you make this step early in the process and you haven't dotted the I's and crossed the T's, you're not going to be capable of actually getting to the stage and making an application that's going to be successful because you're going to lose on it.
Yeah. I want to introduce one other point to think about here. You should think about what you are enforcing the bylaw for and what your objective is here. So in an ideal world, you're enforcing the bylaw because you want whatever is happening to stop, or at least you want to cut it. So that's fine. If you're doing it for vengeance or punishment, I think it's probably wise to think again, because bylaw enforcement is not designed to be punitive. What do I mean by that, Frank? I mean that even if I got an order against your dog about the barking, that doesn't necessarily mean that the barking is going to stop. That doesn't mean that the dog immediately gets removed. It simply means an order has been made and it has to be enforced. It's not going to prevent you, for example, Frank, from putting up a motion to a committee. It's certainly not going to prevent you from being on the committee. It doesn't punish. All it is meant to do is either stop or, more likely, whittle down the behaviour. The only way that you can really get punitive measures for bylaw enforcement is if you enforce the bylaw through the magistrate's court. You can do that.
And that's another big, separate, long, drawn-out process. So, I mean, we're talking at the stage now of starting a bylaw breach, giving someone a reasonable chance to remedy the breach, going through the attempts to self-resolve it, filing application, waiting for conciliation, and then waiting for adjudication. Like that is every bit of a 10-month process.
It is. And the other thing, yes, it is. And meanwhile, the problem can still be occurring. So remember, none of this actually puts an immediate stop to the process. So again, dog barking, it might take, as Frank said, 9 to 10 months for the outcome. That doesn't mean that in the meantime the dog magically stops barking or the problem stops. It just means that your resolution to it is taking that length of time. Coming back, we talked a little bit about tenants before. A bylaw breach also doesn't mean that the tenant gets magically evicted.
No, because the right to occupy a property as a tenant comes from the landlord signing a lease, which the Corp has nothing to do with. So as much as, every tenancy of a CTS lot in Queensland requires the tenant to comply with the bylaws, and if they don't, it's a breach of the lease, it's up to the landlord to actually take action with respect to that breach of the lease, not the corporate. So if the landlord doesn't care, or it's the landlord's son or something like that, the reality is the landlord might not do anything about it. So the corporate's left on its own to do what it can do with respect to that bylaw.
And remember also that the committee can enforce directly against the tenant. They don't have to go through the real estate agent. They don't have to go through the owner. They can initiate this process directly against the tenant. The reverse is also true. The tenant can enforce bylaws directly against somebody else in the scheme. They don't have to go through their agent. That's a common misconception. You should absolutely try and involve the agent and the owner if you can, if you're on the committee, but you don't have to. It's a direct process.
If you're talking about ways to try to resolve the issue, and that's one of the things, yes, it's long and cumbersome, and that's the painful part of it, which we started with. If there's other ways to try to get there to solve the problem, general conversations, it is involving the owner, it is involving the agent if there is one. It might potentially be some form of intervention / mediation from your end, because one of the things with human nature, and that's the thing, if Chris is going to go about my dog barking, and he starts some formal process with respect to that, then I, of course, am not going to be looking to further my friendly relationship with him. And in fact, I might try to niggle him in other ways. That's just the reality of it. So he's having a crack at my dog, I'm going to have a crack at him parking on common property.
I mean, that's it, isn't it, Frank? It's, in that scenario, it might be that for months and months, I have let parking situation go because it wasn't totally bothering me, even though technically it was wrong. But now that I have tried to breach Frank about his barking dog, he's now decided, you know what, I'm not going to live with this whole car parking situation anymore. I'm going to enforce that against you. Always remember, bylaw enforcement can go both ways.
And one of the really big things from a corporate committee perspective is consistency in terms of bylaw enforcement, not selective bylaw enforcement. So if you're going to chop up someone for a particular breach of bylaws, you've got to be ready to chop up everyone. That's the unfortunate nature of it, which of course can become very conflict creating, and particularly, I think we get this more with committees that have inherited bylaw breaches or bylaw behaviour that hasn't been dealt with over previous years. It's really difficult for a new committee to step in and suddenly go to compliance and start enforcing bylaws left, right and centre when the conduct of whatever nature has been let go for potentially decades.
That's right, Frank. It's a tough one, that one. Let's recap. I'm going to bring this back for a final look. So here it is, right from the top. We'll chuck up that link in a second. Practice direction 6, all of this, and you'll see this split up into applications by body corporate, applications by owner or occupier, and then we have the direct one that I spoke about just before. There's an interesting provision in the legislation where you actually can dispense with all of that, but it would need to be for some pretty exceptional circumstances. I can tell you in all my time as Commissioner, we never had one of those qualify. The actual chart itself, let's recap. Section 1, allegation. Section 2, or Part 2, consideration. Big red line here, decision. This is challenge phase. Things might actually cease at phase 3, but if not, they proceed here. It's at phase 4, challenge. And then part 5, dispute. And that's a dispute in 95% of cases in the Commissioner's office, with an option to go to the Magistrates Court if you really want. We're just going to pop that link up on screen now. The process with bylaw enforcement, it's difficult, particularly if it's your first time at this particular rodeo. Legal advice is probably not a bad idea, and especially if you know it's going to be a difficult, the other party's going to be.
It's got to start with whether the bylaw is valid. And again, one of the big furphies in these things, it's in the CNS, it must be right. That's not the case. And the Bylaws Office doesn't check them, they just register them. So it's one of those things that committees have to be particularly careful of, as well as lot owners if they're seeking to enforce bylaws. So as much as Practice Direction 6 is the complete Bible in terms of process for bylaw enforcement, still outside that is the thing actually valid in the first place?
That's right. That's right. And that's kind of a standard issue, but we've run out of time. Look, thanks everybody, and thanks for your patience today. I know that the setup was not ideal, but hopefully you got most of it that you could get out of it today.
But if it's that bad, we'll do another one.
Yeah, that's right. So let us know if you really can't understand it, if you haven't been able to follow it, and thanks for the people who have commented today. But if you're watching this afterwards and it cut out, we've got to this point, let us know. We'll redo the thing another time. Next week, Frank.
Chris is the master of puns, so we're doing H2.
Water ingress next week, everybody's favourite topic, and we may have a guest speaker for that one, so keep tuned for that. Until then, though, thanks everyone for tuning in. Right?
Thank you, Chris. Thank you, everyone.
Thanks for your patience. We'll see you next week. Bye-bye.